Hello there. Let's talk about something that might feel a little heavy at first, but I promise you, exploring it can actually bring a surprising amount of lightness and peace of mind. Have you ever found yourself awake at night, perhaps, pondering the what-ifs? Those quiet moments when the mind drifts to the future, and you might wonder, if something unexpected were to happen to me, if I couldn't speak for myself, who would understand my wishes? Who would make sure things are handled the way I would want? It's a thought that crosses most minds as we gather more life experience, isn't it? It's not about being morbid or expecting the worst. Quite the opposite. It's about acknowledging life's uncertainties and choosing to face them with foresight and care, both for yourself and for the people you love. Thinking about end-of-life planning isn't always the easiest conversation to start, even with ourselves. There can be a natural human tendency to shy away from subjects that touch upon illness, incapacity, or our own mortality. Perhaps it feels like tempting fate, or maybe it just seems overwhelmingly complex. Where would you even begin? You might feel you're perfectly healthy right now, and thankfully so, thinking these matters are for a distant future. Or perhaps you worry about burdening your family, either with the conversation itself or with the responsibilities these plans might entail. Let me reassure you, these feelings are incredibly common and perfectly understandable. Many people put off these important considerations, thinking there will always be a better time, a later that feels more appropriate. But life, as we know, has its own timetable. And the truth is, planning ahead isn't about focusing on an ending. It's about ensuring your values, your choices, and your voice are respected throughout your life's journey, no matter what turns it takes. It's about continuing to exercise your autonomy, even in situations where you might not be able to communicate directly. The real burden, often, is the one that falls upon families when these plans aren't in place. Imagine your loved ones facing a sudden health crisis concerning you. In the midst of their worry and emotional turmoil, they might be confronted with difficult decisions about your medical care or your finances. Without clear guidance from you, they are left to guess what you would have wanted. Would you prefer comfort care or all possible interventions? Who should manage your bank accounts or pay your bills if you're temporarily unable? These questions can lead to immense stress, confusion, and sometimes heartbreaking disagreements among family members, even those with the best intentions. They want to do right by you, but without your expressed wishes, they may struggle to know what right truly means in that context. This is where thoughtful planning becomes an extraordinary gift, a gift of clarity, peace, and unity for those you care about most, offered during a time when they will need it desperately. So, what are we really talking about when we speak of end-of-life planning? At its heart, it's about putting in place certain legal tools that act as your voice when you cannot speak for yourself. These aren't just dry legal documents. They are deeply personal statements about your values, your priorities, and your trust in others. They ensure that your wishes regarding medical treatment are known and followed, and that someone you trust is empowered to manage your practical affairs if needed. Specifically, we're going to focus our conversation today and in our subsequent time together on three cornerstone documents that form the foundation of effective planning: the living will, often part of what's called an advance directive; the healthcare proxy, also known as a medical power of attorney or healthcare agent; and the durable power of attorney for finances. Think of these documents not as rigid constraints, but as maps you draw for your future care and well-being. The living will outlines your preferences for medical treatments in specific end-of-life scenarios or if you are permanently unconscious. It speaks directly to your doctors and family about the types of interventions you would or would not want. The healthcare proxy is where you appoint a specific person, someone you trust deeply, to make healthcare decisions on your behalf if you become unable to make them yourself. This person becomes your advocate, guided by your known wishes, ideally expressed in your living will and conversations you've had. And the durable power of attorney for finances is similar, but it covers your property and financial affairs. You designate someone to manage your bank accounts, pay bills, handle investments, or deal with property matters if you become incapacitated. Together, these documents create a safety net, ensuring continuity and respect for your autonomy across the crucial areas of your life. Taking the step to put these documents in place is an act of profound responsibility and love. It's about saying, "I've thought about the future, and I want to make things as clear and easy as possible for myself and my family." It removes ambiguity, prevents potential conflicts, and allows medical professionals to act confidently according to your expressed desires. It preserves your dignity by ensuring your deeply held beliefs about life and medical care are honored. Far from being a gloomy task, completing this planning often brings an incredible sense of relief and accomplishment. It's like tidying up a cluttered room. Once it's done, you can relax, knowing that things are in order. In our journey together through this topic, this first chapter serves as our starting point, understanding the why. Why is this conversation so important? Why face these potentially uncomfortable thoughts? We've touched upon the peace of mind it brings you, the immense relief it provides your loved ones, and the fundamental way it protects your autonomy and dignity. In our next chapter, we will carefully unpack the what and how of these essential documents. We'll look closely at the living will, the healthcare proxy, and the durable power of attorney, exploring what each one does, how they differ, and what you need to consider when creating them. We'll break down the terminology and make it all feel much more manageable. And finally, in our concluding chapter, we will reflect on the broader implications, revisit the key takeaways, and focus on the feeling of empowerment and security that comes from taking these proactive steps. Our aim is not just to inform you, but to reassure you and empower you to take control of these important aspects of your future, ensuring your voice continues to guide your journey, come what may. For now, let's just sit with the importance of this task, acknowledging its significance, and preparing ourselves to learn more about the tools that can help us navigate the future with confidence and care. All right, now that we've acknowledged why thinking about these matters is so profoundly important for your own peace of mind and as a true act of love for your family, let's gently move into the what and the how. We're going to take a closer look at those three key legal documents we mentioned: the living will, the healthcare proxy, and the durable power of attorney for finances. Think of these as the practical tools you can put in place now to ensure your wishes are understood and respected down the road. It might seem like navigating legal waters, but I want to assure you the core concepts are quite straightforward, and understanding them is well within your grasp. We'll break them down together, piece by piece. First, let's talk about the living will. You might also hear this called a declaration relating to use of life-sustaining treatment or similar terms, and it's often part of a larger document called an advance directive. At its heart, a living will is your written statement directly to your doctors, your family, and anyone involved in your care, outlining the kinds of medical treatments you would or would not want if you were diagnosed with a terminal condition, or if you were in a state of permanent unconsciousness, like a persistent vegetative state, and you were unable to communicate your wishes yourself. This isn't about routine medical care. It specifically addresses end-of-life scenarios and choices regarding life-sustaining procedures. Why is this document so vital? Imagine a situation where you are very ill, perhaps after a severe stroke or accident. and you cannot speak or make decisions, the medical team might propose various treatments, things like being put on a breathing machine, mechanical ventilation, receiving nutrition and hydration through tubes, undergoing cardiopulmonary resuscitation, CPR, if your heart stops, or starting dialysis if your kidneys fail. These are powerful interventions that can prolong life, but they may not align with everyone's values or definition of acceptable quality of life, especially if the prognosis for recovery is poor. Without a living will, your doctors and family are left guessing. Would you want everything possible done, or would you prefer to focus on comfort, dignity, and allowing a natural passing? Your living will removes that terrible burden of uncertainty. It clearly states your preferences. For instance, you might specify that you do want treatments if they offer a reasonable hope of recovery, but you would not want certain aggressive interventions if they would only serve to prolong the dying process without restoring consciousness or meaningful quality of life. Many people find immense relief in knowing they have specified they want all measures taken to ensure comfort and manage pain, even if they choose to forego other life-sustaining treatments. It's your chance to define what living well means to you, right to the very end. Consider Mrs. Peterson, a vibrant woman who cherished her independence and feared prolonged dependence on machines. Her clear living will stated her desire to forego artificial ventilation and feeding tubes if she were permanently unconscious. When she suffered a catastrophic brain hemorrhage, her family, though heartbroken, found solace in knowing they were honoring her deeply held wishes by focusing on comfort care, just as she had directed. This clarity prevented agonizing debates and allowed them to focus on being present with her in her final days. When creating a living will, you'll typically encounter sections addressing specific treatments. You'll have the opportunity to indicate your choices regarding CPR, ventilation, artificial nutrition and hydration, dialysis, and perhaps others. It's important to think carefully about these choices and what they mean to you. You might also include statements about your desire for pain relief and comfort care, often referred to as palliative care, which is a crucial aspect for many people. While standard forms provide a good starting point, you can often add specific instructions or personal statements that reflect your unique values. Remember, terminology and specific requirements for living wills can vary from state to state, so it's generally wise to use a form valid in your state, often available from state bar associations, medical associations, or organizations focused on aging. And crucially, your living will isn't set in stone. You can, and should, review and update it if your health changes or your views evolve over time. Now, let's turn to the second pillar, the healthcare proxy. This document is sometimes called a medical power of attorney, designation of healthcare surrogate, or healthcare agent. While the living will outlines your wishes for specific treatments in certain situations, the healthcare proxy addresses a different, equally vital need. Who will make healthcare decisions for you if you become unable to make them yourself, regardless of whether it's an end-of-life situation or a temporary incapacity? Think about it. Medicine is complex, and situations can arise that aren't explicitly covered in your living will. You might be temporarily unconscious after surgery, or perhaps develop dementia and lose the ability to understand treatment options. In these cases, you need a trusted person, your agent or proxy, who can step in and make decisions on your behalf. This person becomes your voice, your advocate, in the healthcare system. Their primary responsibility is to make decisions based on what they know about your wishes. This is why the living will is so helpful. It gives your agent concrete guidance. But beyond that, the agent should ideally be someone you've had deep conversations with about your broader health values, your fears, your hopes, and your philosophy on life. and quality of life. If a situation arises that your living will doesn't cover, your agent's role is to make the choice they believe you would make if you were able. If your wishes aren't known at all for a specific situation, they would typically be guided to act in your best interest. Choosing your healthcare proxy is arguably one of the most important decisions in this process. Who do you trust implicitly to understand and honor your values, even under pressure? Your agent should be someone who is willing and able to take on this responsibility, can remain relatively calm in a crisis, is not afraid to ask questions of medical staff, can be assertive in advocating for your wishes, understands your values. This requires open conversation, and ideally lives reasonably close by, although that's not always essential. It's crucial to name one primary agent, but it's also highly recommended to name at least one or even two alternate agents, in case your first choice is unable or unwilling to serve when the time comes. Think about Mr. Chen. He named his daughter, Mei, as his healthcare proxy. They had spoken often about his desire to remain at home if possible and his dislike of hospitals. When Mr. Chen developed pneumonia and the hospital suggested aggressive treatment there, Mei, armed with her understanding of his values and the guidance in his advance directive, was able to advocate strongly for a plan that allowed him to receive effective treatment in the comfort of his own home, supported by hospice care. Her role as proxy empowered her to ensure his preferences were central to his care plan. It's critical to understand that your healthcare proxy only gains authority to make decisions if and when medical professionals determine that you lack the capacity to make them yourself. Until that point, you always make your own decisions. You should give a copy of your signed healthcare proxy document and your living will to your agents, your doctor, and perhaps other close family members. Finally, let's discuss the third essential document, the durable power of attorney for finances. This is distinct from the healthcare proxy. While the healthcare proxy deals with medical decisions, the durable power of attorney, DPOA, for finances deals with your money and property. You appoint someone, again, often called an agent or attorney in fact, though they don't need to be a lawyer, to manage your financial affairs if you become unable to do so. The key word here is durable. A regular power of attorney typically ends if you become incapacitated. A durable power of attorney specifically continues, or sometimes only begins, if you become incapacitated, which is exactly when it's most needed. Why is this document so crucial? Imagine you have a sudden illness or injury that leaves you hospitalized and perhaps confused for weeks or months. Who will pay your mortgage or rent? Who will access your bank account to pay the utility bills or medical expenses? Who will manage your investments, file your taxes, or deal with your insurance claims? Without a DPOA for finances, your family might find themselves locked out of your accounts, unable to manage your affairs without going through a potentially lengthy, expensive, and public court process to have a guardian or conservator appointed. A DPOA allows someone you trust to step in seamlessly and handle these essential tasks, ensuring your financial life doesn't unravel during a health crisis. It protects your assets and prevents unnecessary hardship for both you and your family. Consider the case of Sarah, whose mother, Ellen, had a DPOA naming Sarah as her agent. When Ellen developed Alzheimer's and could no longer manage her bills, Sarah used the DPOA to access her mother's accounts, pay for her care, manage her pension deposits, and eventually sell her house to fund her long-term care needs, all according to the powers granted in the document. This avoided court intervention and ensured Ellen's resources were used for her benefit exactly as needed. Choosing your agent for financial matters requires perhaps even more careful consideration regarding trustworthiness than the healthcare proxy due to the potential for financial misuse. Your agent should be meticulously honest, responsible, organized, and capable of handling financial tasks, or willing to seek professional help, like from an accountant when needed. Again, naming alternates is wise. When creating the DPOA, you'll need to decide what powers to grant your agent. These can be very broad, covering almost any financial transaction, or they can be limited to specific tasks. You might also decide whether the DPOA takes effect immediately upon signing, useful if you need help right away or want to avoid potential delays in proving incapacity, or only springs into effect upon a doctor's certification of your incapacity, which some prefer for control, though it can sometimes lead to logistical hurdles. Given the potential power this document grants, it's often advisable to consult with an elder law attorney to ensure it's drafted correctly according to your state's laws and reflects your specific wishes and circumstances. They can help you understand the implications of immediate versus springing powers and discuss potential safeguards if needed. These three documents, the living will, the healthcare proxy, and the durable power of attorney for finances, form a powerful triad, protecting your wishes regarding your health, your voice in medical decisions, and your financial stability when you might be vulnerable. They work together, covering different but equally critical aspects of your life. Having them in place isn't just about preparing for the end. It's about ensuring your autonomy and well-being throughout your later years, no matter what health challenges may arise. It's about replacing uncertainty with clarity, potential conflict with prepared guidance, and anxiety with the quiet confidence that comes from knowing you've put your affairs in order. In our next chapter, we'll bring all this together, reflecting on the profound sense of empowerment this planning provides and offering some final thoughts on carrying this forward. So, we've journeyed together through what might initially have seemed like a daunting landscape, the realm of planning for future what-ifs regarding your health and finances. We started by acknowledging those quiet, sometimes unsettling thoughts about ensuring your wishes are known and respected if you couldn't speak for yourself. We recognized that thinking about these things isn't about dwelling on negativity, but rather about embracing foresight, responsibility, and profound care for yourself and those you hold dear. It's about transforming potential anxiety into a sense of preparedness and peace. In our last conversation, we delved into the practical tools that make this possible, the what and how of end-of-life planning. We carefully unpacked the living will, understanding it as your personal declaration regarding specific life-sustaining treatments in end-of-life situations or permanent unconsciousness. It's your way of telling your doctors and family, "This is what I value. This is the kind of care I would or would not want under these specific circumstances." It lifts the heavy burden of guessing from your loved one's shoulders when it comes to incredibly difficult decisions about things like ventilators or feeding tubes, ensuring your deeply held beliefs about quality of life are honored. We talked about the importance of using state-specific forms and remembering that you can always revisit and update this document as your life or views change. Then, we explored the crucial role of the healthcare proxy, or medical power of attorney. We saw how this document complements the living will by appointing a specific trusted person, your agent, to make any healthcare decisions for you, should you become unable to make them yourself, whether temporarily or permanently. This person becomes your voice, your advocate, guided by your living will, and, just as importantly, by the conversations you've had with them about your broader health values and wishes. We emphasized the careful thought required in selecting this agent, someone who truly understands you and can act firmly on your behalf, and the wisdom of naming alternates just in case. And finally, we addressed the practicalities of everyday life during incapacity with the durable power of attorney for finances. We understood that this separate but equally vital document empowers a trusted individual to manage your financial affairs, paying bills, handling bank accounts, managing property, if you cannot. We stressed the durable aspect, meaning it remains valid even if you become incapacitated precisely when it's needed most. This prevents your financial life from grinding to a halt and protects your family from the potential stress and expense of court proceedings to manage your affairs. We touched upon the critical need for trustworthiness in selecting this agent, the options for when the power takes effect, and the potential value of seeking legal counsel to ensure it's tailored correctly. Seeing these three documents together, the living will, the healthcare proxy, and the durable power of attorney for finances, reveals how they form a comprehensive safety net. They don't overlap unnecessarily. Instead, they cover distinct but interconnected areas, ensuring your wishes regarding medical treatment are known. Your voice in healthcare decisions is represented by someone you trust, and your financial stability is maintained even when you cannot manage things yourself. They work in concert to protect your autonomy and well-being across the board. Now let's step back for a moment and reflect on the larger meaning of undertaking this planning. It's easy to get caught up in the details of forms and legal terms, but what does it truly signify? Completing these documents is far more than just a legal formality. It is, perhaps, one of the most profound acts of love and responsibility you can offer your family. Think back to the scenario we discussed earlier. Your loved ones facing a crisis, consumed with worry about you, and then having to guess at life and death decisions or struggle with managing your affairs. The stress, the potential for disagreement, the guilt of uncertainty. These are heavy burdens. By putting your wishes clearly in writing and designating trusted decision-makers, you lift that weight. You provide them with the incredible gift of clarity and unity during what will undoubtedly be a challenging time. You allow them to focus their energy not on deciphering your wishes or battling confusion, but on supporting you and each other. It's a gesture of care that echoes long after the documents are signed. Furthermore, this planning is a powerful statement about your own dignity and ongoing control over your life. Sometimes people worry that creating these documents means giving up control. The reality is precisely the opposite. In situations where illness or injury might otherwise rob you of your ability to direct your own care or manage your affairs, these documents extend your control. They ensure that your voice, reflecting your lifelong values and preferences, continues to guide your journey. They ensure that decisions made for you are the decisions you would have made. It's about maintaining your personhood, your autonomy, even when facing vulnerability. Let's also acknowledge the process itself. Creating these documents isn't just about signing papers. It often involves, and certainly should involve, important conversations. Talking with the person you are considering naming as your healthcare proxy or financial agent, discussing your values, your fears, your hopes regarding future care. These conversations are invaluable. They deepen understanding, strengthen bonds, and ensure your chosen agents are truly prepared to act according to your wishes. Even sharing your completed documents and the reasoning behind your choices with other close family members can foster openness and prevent misunderstandings down the road. This communication is almost as important as the documents themselves. Taking the time to contemplate these matters, to acknowledge the reality that life includes uncertainty and eventual mortality, is not morbid. It is mature, responsible, and ultimately liberating. By facing these possibilities pragmatically and preparing thoughtfully, you free yourself, to a degree, from future anxieties. You can live more fully in the present, knowing you have taken steps to ensure your values will be respected and your loved ones will be spared unnecessary hardship. There's a unique and profound sense of relief, a quiet satisfaction that often comes from getting these affairs in order. It's like putting your house in order before a long journey. You can relax and focus on the road ahead. So, I want to genuinely encourage you. Engaging with this topic, even just by listening and thinking through these ideas, takes courage and foresight. You are already demonstrating care for yourself and your future. Completing these legal documents, your living will, your healthcare proxy, your durable power of attorney for finances, is an act of profound self-respect and empowerment. It's you taking charge, making conscious choices about how you wish to be treated and cared for throughout your entire life. It transforms you from potentially being a passive recipient of decisions to being the author of your own care plan, ensuring your story unfolds according to your script. The path forward doesn't need to be rushed or overwhelming. Perhaps your next step is simply to reflect further on your own values regarding medical care. Maybe it's researching the specific forms and laws in your state. Perhaps it's initiating that crucial conversation with the person you trust most, the one you might ask to be your agent. Or maybe it's scheduling a consultation with an elder law attorney who can provide personalized guidance. Whatever your next step, however small it feels, take it with the confidence that you are doing something incredibly positive and worthwhile. You are weaving a stronger fabric of security and care for your future. Ultimately, this planning isn't truly about the end of life. It's about affirming your life, your values, and your connections right now, and projecting that affirmation into the future. It's about ensuring that your voice, the voice that has expressed wisdom, laughter, opinions, and love throughout your years, continues to resonate with clarity and authority, guiding your path with dignity and intention, come what may. It's the peace of mind in knowing you've prepared, the relief you offer your loved ones, and the enduring respect you show for the life you have lived and continue to live. Thank you for taking this time to explore these important considerations.